Can y'all see it?
Yes.
Okay. Okay, so this is week three. Week three, we usually want to discuss matters involving legal kind of proceedings and that kind of thing. So this week it's interfacing with judicial or public officers, kind of just in general. Points we want to cover. We want to look at the Fourth Amendment and other laws that deal with your protections from illegal search and seizure. We already talked about like kind of policing procedure that we have, our rules to follow. But I'll cover some more stuff on that. Probable cause and reasonable suspicion, excuse me. We'll look at some common causes of action in response to claims by police, other entities. We'll look at issues of color of authority or colorable law and some other legal protections you have. And if we have time, I want to go over our three main documents that we use for how we would respond on your behalf to like criminal claims against you. So that'll be letters rogatory, our notice of jurisdiction suspension, and we have another document called an action in quo warranto. So first, here's another law in addition to the Fourth Amendment that deals with protections of your property. So this is in the United States Code, Title 28, Section 1609. This deals with immunity from attachment and execution of property of a foreign state. So it reads, subject to existing international agreements to which the U.S. is a party at the time of enactment of this act, the property in the United States of a foreign state shall be immune from attachment, arrest, and execution, except as provided in Section 1610 and 1611. And those two other ones deal with like if for some reason you were to waive your rights to immunity, or maybe through some like commercial activity with your property, you waive your right to immunity, but we don't want to be doing that. But basically, as you start to acquire assets, real estate, vehicles, and such, and you're transferring them, into your trust, that property is becomes explicitly the property of a foreign government, right, under your honor trust. So you have special immunities from search and seizure, attachment, confiscation, et cetera, et cetera. Actually, once you get your house under a trust and clear title, that property essentially becomes like the equivalent of an embassy property. So if somebody wanted to get a warrant to search and that kind of thing, they would actually need a federal warrant. They couldn't just go to like the state or that kind of thing. So that's one law for property. The Fourth Amendment to the Constitution. This was very important, dealing with like police and that kind of thing. It reads the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the Fourth Amendment is important because it establishes probable cause, but it also establishes potential issues of whether suspicion is reasonable. So in the next slide, we can define probable cause. Apparent facts discovered through logical inquiry that would lead a reasonably intelligent and prudent person to believe that an accused person has committed a crime, thereby warranting his or her prosecution, or that a cause of action has accrued justifying a civil lawsuit. So what that actually means is, for someone to have probable cause, basically there has to actually be a witness and an injured party to be an accuser against you. And then, a police officer or some other officer can go and inquire into the matter. They can detain you and, do their investigation. Through a court case that I'm going to show on the next slide, they implement, when you hear about reasonable suspicion, which is something else. So basically, reasonable suspicion, which an officer can use to detain you or like hold you up for a second is the case law standard, but the constitutional standard is probable cause. But both are legal, but there's a distinct difference. So further, it says probable cause is a level of reasonable belief based on facts that can be articulated. So again, somebody has to come and make an accusation against you that can be like verified. Goes on to say before a person can be sued or arrested and prosecuted, the civil plaintiff or police and prosecutor must possess enough facts that would lead a reasonable person to believe the claim or charge is true. Okay. So this was a case in 1968 that basically established regulations around stop and frisk, or also called Terry stops. And this basically defined reasonable suspicion. So reasonable suspicion is a legal standard of proof in the U.S. law that is less than probable cause, which is the legal standard for arrest and warrants, but is more than inchoate and unparticularized suspicion or hunch. So inchoate is a word that means like preemptively, like making an assumption before any type of inquiry is done to approach somebody, like a police officer stopping you. Reasonable suspicion is above that, but less than probable cause. Again, it must be based on specific and articulated facts, taken together with rational inferences from those facts, and the suspicion must be associated with the specific individual. If police additionally have reasonable suspicion that a person is so detained, and detained is distinct from arrested. If a police officer stops you in a traffic stop or something like that, that's detainment. Arrest is actually being, taken into custody. So detained is armed and dangerous. They may frisk the person for weapons, but not for contraband like drugs. So obviously we shouldn't be messing with drugs and that kind of thing. But I'll show in the next slide that frisk deals with they can do like pat downs, but as soon as they go into your pocket or that kind of thing, that is now an unlawful detainment or arrest. So you can come back and sue them for those kind of things. So, however, if the police develop probable cause during a weapons frisk by, for example, feeling something that could be a weapon or contraband, they may then conduct, full search. So, in that case, as we just said, the Supreme Court ruled that a person can be stopped and briefly detained by an officer based on a reasonable suspicion of involvement in a punishable crime. If the officer has reasonable suspicion that the detainee is armed, the officer may perform a pat down of the person's outer garments for weapons. But they can't go in your pockets, anything like that. If you don't consent to vehicle searches or that kind of thing, they can't do that. That's grounds for a lawsuit. And then you mentioned the Fourth Amendment, such as detention does not violate the Fourth Amendment prohibition on unreasonable searches and seizure, though it must be brief. So they can't hold you up all day, during a detainment either. That's unlawful restraint or unlawful imprisonment as well. And reasonable suspicion does not provide grounds for arrest. That's important. Sometimes you see in the state code, it'll say that they can make arrests on reasonable suspicion, but the case law and constitutional law says otherwise. So that's important. However, an arrest can be made if facts discovered during the detention provide probable cause that the suspect has committed a crime. So we saw that already. So what are your counteractions against that? Two of the common ones that we'll use, obviously unlawful detention, imprisonment, or in the Texas law, I think is unlawful restraint. So under that code, a person commits an offense if he intentionally or knowingly restrains another person. So, obviously restrain means to restrict a person's movements without consent. The other one is kidnapping. And there is a distinction between state and federal level kidnapping. I think state is defined as an actual child. I think the ages is like 14 to 17. But at the federal level is anybody. And that's defined as we have a person commits an offense if he intentionally or knowingly abducts another person. And abduction is defined as it means to restrain a person with intent to prevent his liberation by secretly holding him in a place where he is not likely to be found, or using or threatening to use deadly force. That's from the state criminal code or penal code in Texas. Then you have federal kidnapping under Title 18. Title 18 deals with all of your crimes and like criminal procedure stuff. So this, y'all don't have to like memorize all of this, but it's good to like, be familiar with, even if you're not a jurist. But here it says whoever unlawfully seizes, confines, inveigles, decoys, kidnaps, abducts, or carries away and holds for ransom or reward, or otherwise any person, except in the case of a minor, by the parent thereof, when, and I pulled this particular clause under there, when the person is a foreign official, an internationally protected person, or an official guest, as those terms are defined in this other section. So that's important because when you are, let's say you get pulled over and arrested for something, and we know that it's unlawful, we can bring the federal charge of kidnapping. It's not just unlawful detainment. It's not just, I don't know, whatever other mechanisms we can use. We can bring, a number of federal charges against these entities. And this is one example. So that section mentioned 1116B, this deals with actually murder or manslaughter of foreign officials, official guests, or internationally protected persons, which is defined here. And it means a chief of state or the political equivalent, head of government, or foreign minister, that's y'all, whenever such person is in a county other than his own, and any member of his family accompanying him, or any other representative, officer, employee, or agent of the United States, a foreign government, or other international organization. I don't have to read the whole thing, but you kind of get the gist of it. You have criminal protections against people injuring you, as a member of an indigenous government and an internationally protected person. Here's another one, and all of these are in your protocol manual. We have our notices to officers. So this is just pulling that again. I think I covered that in our first class we did, but just kind of re-emphasizing it. This is another one that has protections for internationally protected persons. This one deals with like bodily injury. I'm not going to read all of it, but you can see at the bottom, whoever in commission of any such act uses a deadly or dangerous weapon, for example, or inflicts bodily injury, shall be fined under this title or imprisoned not more than 10 years or both. So some more, heavy fines. This one deals with protections of your property in the same manner. Anyone who obfuscates this act, police or otherwise, really anybody, shall be fined under this title or imprisoned not more than 5 years or both. Same kind of language. Here's another one. I took a screenshot of it. It's kind of blurry, but this is an important one that deals with conspiracies against rights or deprivation against your rights under color of authority. So you probably heard Ali talk about colorable law, Title 42 cases, that kind of thing. That's the civil action for deprivation of rights, but it's also criminal as well, again, under Title 18, which is all your crime stuff. So I can read a little bit of it. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in whatever jurisdiction it is, in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States. So that's all of our indigenous treaties and that kind of stuff as well. And there's more to that, but you can see down here, they shall be fined under this title or imprisoned not more than 10 years. And then if death results, which may include incidents of kidnapping, like we just mentioned, sexual abuse, that kind of thing, they'll be fined under this title or imprisoned for any number of years or life imprisonment, or maybe even sentenced to death. So there's very stiff, penalties against anyone committing, colorable actions to take your rights away from you, indigenous or otherwise. They can be really seriously penalized. So we want to kind of make this kind of stuff, commonplace amongst our people, especially our nationals, but even non-nationals need to know this stuff too. That's how things start to change when we start to hold people accountable, And this was what I mentioned, the Title 42 case. So this is the exact same as what I just showed here. This is the criminal. This is the civil action. So like monetary damages, injunctive relief, that kind of stuff. Same basic thing. So anyone who deprives you of your rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress. So you have a lot of actions we can take against these people. Under another thing under this particular section, it has certain exemptions for judicial officers like judges. So a lot of times judges have immunity from certain types of civil actions, but criminal, they can still be charged just like any other criminal for violation. So we can get the judge under Title 18 and that kind of stuff as well. So this is the other particular point: malicious prosecution. Whenever somebody sues you, if you beat the case and you can prove that there was no probable cause, like we discussed earlier, that's important. You can come back and countersue them. I think the statute of limitations is about a year, but you can come back and sue them for malicious prosecution, and that can be a civil case, or you can move to get them charged criminally for malicious prosecution. So that's another, I guess, strategy we can employ. As if any cases and stuff are coming up for our nationals or non-nationals, we can pretty easily, respond and make a lot of different counterclaims. So that's just another example. Along with that is the concept of fictitious plaintiff. That's important. So a fictitious plaintiff is a person appearing as a claimant but with no right to do so. So, for example, in a case where there's no probable cause to come against you, whoever the plaintiff is a fictitious entity. In likewise manner, literally, your states are fictions. So in a criminal case, let's say in Texas, it's the state of Texas versus you. That's fictitious plaintiff. There has to be a real injured party. The state is a fiction that you can't injure. So that applies in stuff like traffic tickets, for example. If you just get like a speeding ticket or something, you didn't actually injure anybody. So therefore, you automatically know that that traffic citation, which is a misdemeanor, is malicious or unlawful prosecution. You know, so that's an example of that. And then my last slide I have is deals with oaths and bonds. So all of your public officials and employees, they have to have one, an oath of office on record, which is their oath to defend the Constitution, all that kind of stuff. And two, they have to have a surety bond on record with their oath, which acts as insurance in case of their misconduct or malfeasance, which is a word that just means intentional conduct that is unlawful. That's important because sometimes what you'll find is that judges and other public officials, they might not even have an oath of office. So you might have somebody literally just posing as a judge with no actual lawful authority to do so. But they're sitting on the bench and they're handing out, years. You know what I'm saying? But you might find through your research that they're literally not even a real, judge or public official. You know what I mean? So there's crimes for that, such as in the Texas Code, impersonating a public servant. You know, so that's a person commits an offense under that if the person impersonates public servant with intent to induce another to submit the person's pretended official authority or to rely on the person's pretended official acts. And there's a bunch more to that, but so there's a lot of different ways we can come at these people. Another thing we can do along with all those various lawsuit types under Title 18, Title 42 I just showed, we can also make claims on their actual bond, because that's their insurance. So we can go to the insurance company and make a claim against them for violation and get paid that way too. You know, I had some other stuff here. Okay, so this is some further international law protections you have. I'm not gonna go over all of this, but just briefly, this is from the United Nations. This is the UN Declaration on the Rights of Indigenous People. So all of the stuff in here applies to us in ARNA, and I guess in the IPA, too. Um, so I'll read a few articles out of here, and there's all kind of international laws like this protecting our people specifically. Um, what are some I can read? Article 2, indigenous peoples and individuals are free and equal to all other peoples and individuals and have the right to be free from any kind of discrimination in the exercise of their rights, in particular that based on their indigenous origin or identity. For example, indigenous people have the right to self-determination. So, you know, if you present your IDs to like a officer or something, they can't try to tell you you're not who you say you are. For example, that's color of authority. That's a lawsuit. You know, um, what are some other ones? Every individual has a right to a nationality. Article 7 is important. Indigenous individuals have the rights to life, physical and mental integrity, liberty, and security of your person. So, people committing injuries against you is genocide. That's a whole nother crime. All kind of stuff like that. But there's 46 articles in here, so there's a whole lot of stuff in here. Article 8 is important. Indigenous peoples and individuals have the right not to be subjected to forced assimilation or destruction of your culture. So there's a lot of that in here. When we're filing our federal lawsuits, we can include, these articles as additional rights that whatever officials or officers you're dealing with may be conspiring against or depriving you of. So that stuff you can just like pad into your cases, if as those kind of things come up. So the next kind of segment I want to discuss is, so we talked about suing officials. You can also just move to get elected and appointed officials removed from office if necessary. There's a lot of like political corruption all over the country, that kind of thing. But in the same laws that organize for election of officials, you find the procedure for their removal as well. So this is from the Texas Local Government Code, and this section deals with removal of county officers from office. So that's done by removal by petition and trial. Let me scroll here. Official misconduct and incompetency. Those are some of the main ways you remove people. And you can see the officers subject to removal here is literally basically everybody. All your attorneys, judges, clerks, treasurer, sheriff, tax assessor, constable, basically everyone. If they're doing dirt, it's pretty easy for someone to file a petition and get them removed. Just for example, in Texas counties. So your general grounds for removal: incompetency, official misconduct, or actually intoxication on or off duty caused by drinking an alcoholic beverage. That's another thing. So you can see you would just file a petition that can be done by basically anybody. And you will file that case or petition in a district court, and you can move to get whoever out of office, basically virtually anybody in the county, if necessary. Now, obviously, we understand, because of the note security bond cycle and the primary dealers and these third parties, we understand that these elected officials, they're not really in control of anything, you could say. So to a certain degree, it doesn't really matter too much who's in office, just based on the way that government is actually ran. But it's a good thing for people to at least know this kind of stuff, because if we can continually like get anyone who violates removed, eventually they run out of puppets to use. You know what I'm saying? And then kind of you'll see the whole system start to have to shift, because the people will be more civilly and politically, educated and active. So that's an example for like Texas counties. When you look at the city of Houston, for example, we can go into the codes and city ordinances. The city of Houston is a home rule city, which basically means, in addition to the Texas Constitution, the people in the city are ruled by the city's own charter. So basically, like an individual specific municipality constitution. But in like manner as the county, Your mayor, your city council, other city employees, they can be removed as well. So if you go through this section here under the charter, you'll come to a section on the recall of officers. So in a similar manner, all the people have to do is petition, and you can see here you need at least 25% of the total people who voted in an election for an officer. If you can just get a quarter or 25%, not of those same voters, but just of the out of the constituents of the city to submit a petition, you can get those same people removed. If you have a crooked mayor, city councilman, I don't know, city secretary, whoever, it's the same process all across the country to get those people out of the way. You know what I mean? So, so political corruption doesn't have to be an issue like it has been in a lot of places.
Hey, Bach,
Yeah.
after the meeting, do you mind sending those links for those that don't have it?
Oh yeah, for sure. I'll
Like just
post the
email the link out? Yeah.
yeah, I'll post everything in the Telegram, and yeah, so
Cool,
everyone will
cool.
have it. So that's like removing people if necessary. We won't necessarily be doing that, but maybe sometimes. Okay, so let me jump over to the protocol manual. So these are the three main instruments that we'll use if you end up being charged with like a criminal case as a national. And this is, of course, if you're in the right. We don't want to be defending people who are actually out here, being like part-time criminals and stuff. Like, you know what I'm saying? People actually doing dirt. If you're catching cases and stuff, we can still identify you as a national. So at least you don't get charged with like fraud and that kind of thing. But we're probably not going to actually help you fight the case because you're also violating our law as well. You know, that's kind of important because I think a lot of people kind of have this mindset that ARNA is like a get out of jail free card or something like that. But that's not the case. We want to be the most upright, civilly astute, people or whatever like in the country. You know what I'm saying? So don't be out here doing dirt, basically. But this first document is an international letters rogatory. A letters rogatory is a formal request or demand from one court to another, to a foreign court. So this is going to be ARNA. Let's say you get pulled over, traffic stop example. You hand them your ID or whatever they say is fake or something, and they lock you up, for example. We can send this document basically to identify you as a national. We can show your IDs, how long you've been a national, all that kind of stuff. And this is also, you can see it's the demand for release, if that's how we're going to be using it. Again, if you're somebody who's actually after we do our investigation, if we determine you are probably guilty or in violation of our constitution, our constitution, we'll still identify you, but we're not necessarily going to be able to like work to get you out. You know what I mean? But this is an initial communication to identify you as our national and as an internationally protected person. And one other thing we'll do, pending our investigation, is what we can do is ARNA can take on the charges for you, and then we can invoke jurisdictional immunity. Because here in the middle, you can see under Title 28, if you read in that law, it actually states that foreign governments are basically immune from U.S. courts. So that's a really powerful law that we can use to protect you and us in this type of situation. So we can take on charges for you as the tribe, and then we can invoke that foreign immunity, and basically get the charges dropped through that aspect. So basically, anytime a national is dealing with some type of criminal charge, they might be charging you for fraud, ID fraud, something like that. We can send this to say, no, we know who this person is. They're a part of our group. Get that out of here, basically. And that'll be signed by Ali or by me or some other jurist. So the next document is important. This is your notice of suspension of jurisdiction. You can see this will come from our court and be sent into their court, basically as a judgment. And you can see you'll be listed up here with ARNA. You can see we're actually, when we send this document to them, we'll be going literally against the case number and the bond numbers from the general obligation bonds themselves, because so like we're literally suing that asset. And ultimately what that ends up doing is, if you think about on your credit report, if you have derogatory marks or adverse marks on your credit report, your credit drops. So when we sue the bond itself, the ratings on the bonds that they're trying to sell to, your bond holders, your primary dealers, those drop. So that literally damages their ability to keep getting funding. You know what I'm saying? So when that happens, those primary dealers on the general obligation bonds, you might start seeing them pull out of their investment, because they're the people who are actually funding the government. But if they see that the ability of the to pay them back through our debts and that kind of thing in these cases, which are also securitized, they might stop lending to the states and these other quasi jurisdiction entities. And then you'll see something like a Flint, Michigan, where the city goes bankrupt. You know what I'm saying? So we can really make a lot of like noise and trouble for these people through these kind of mechanisms. But you can see we're going to sue the case, the bond, all the agents. Last class we talked about seeding company, the DTC, all those entities involved in these financial transactions, because you're thinking that you're being charged with a crime by the state or the people of the state. But what is actually taking place is literally just a financial transaction, So your indictment, or if it's a traffic citation, something like that, that document literally is going to be stamped as a check. Now, they're not going to tell you that, but it's just like with like mortgages, any other type of loan instruments, promissory notes, all of those get securitized and turned over to third parties who make a whole lot of money off of that just piece of paper with your signature. In court cases, the indictment, it's the exact same thing happening, you know. So so we'll send this document to them, suspending their jurisdiction. We'll address the merit claims, which is like whatever they're charging you with. Again, if we find you innocent, then we can kill those merit claims through our own court, our own court. We can find you innocent of those. We'll also cite all of the financial stuff I just mentioned, the securitization fraud, the bond numbers, the indictment, et cetera, et cetera. Basically, we're proving that the interest in this case is not the states or like the court. The interest is whoever those third party beneficial owners are on the general obligation bonds for that jurisdiction you're in. You know, so basically between those two, we can like nullify and kind of like dissolve their entire prosecution against you. You know, another important. This is a really important case. You may not memorize like everything I'm showing. You don't have to, but this is an important case to be familiar with because this establishes corporate tort doctrine. Bank of America versus Planners Bank of Georgia. So what this established was, as a member of a corporation, a government never exercises its sovereignty. It acts merely as a corporator. And further, that when a government becomes a partner in any trading company, it divests itself, so far as it concerns the transactions of that company, of its sovereign character and takes that of a private citizen. So that means that the state, the courts, the public officials operating those things, they're divested of their ability to adjudicate. If we're able to prove this bond operation and the securitization and all of that, that nullifies their ability to prosecute you. So that's very important because all these cases where our people are getting railroaded, I'm highlighting stuff. Okay, all those cases where our people are like just getting abused by the system, I think it's like, I mentioned this in the class a while ago, but I think it's like 1 out of 3, black men are going to get arrested or go to jail or prison, that kind of thing. All the money that they're making off of us, off of, literal still slavery, by having your nationality and having processes like this, we can like obfuscate all of that. We can kill like all of those cases against you, if you're, again, if you're in the right, you know. So we have good defense against that. So that's the notice of suspension. Then the third document is going to be something called an action in quo warranto. And you can see we have similar case caption here. What quo warranto translates to is by what authority, or we're asking what warrants the prosecution against you. By what authority is the judge, the prosecutor, how are they acting? Um, so I can read a couple of these points. At point A, we're sending this as a discovery demand. So we demand a front and back certified copy of the original indictment for review to establish whether or not this case has been converted into a financial security and to see who the security's trustee or intermediary is for the above entity. That's important because, like I mentioned previously, they're securitizing the indictment, meaning they're stamping it as like a blank check to themselves. And the same way, for those of y'all, as y'all get familiar with our financial recovery processes and debt challenge processes, we'll use things like freedom of information requests to send to the alleged creditor or alleged claimants against you. The action in quo warranto serves that purpose for like legal proceedings. So let's say you have like a credit card company billing you for a debt. We can send a freedom of information request demanding that they establish by what authority they're making that claim. We want to see the original alleged contract you have that created the debt and that kind of thing. We want to get that information from that company. Likewise, in a court case, you can kind of ask for the same type of information through this action in quo warranto. So we want to see what's the original instrument that allows you to bring this claim against me, and they're not going to give it to you, because that will prove the fraud and the commercial interest that's taking place. That will because that exists, that kills any organic claims. So whatever charges they have to be out of here. But we'll ask for that, the original indictment. We'll also demand the oaths of both the prosecutor and all the judges to see whether or not they have an oath to the state and federal constitution. So that's, like I mentioned earlier, how a lot of judges and all type of different officials, county clerks, etc., a lot of times they don't even have an oath, but they're up there handing out life sentences, etc., etc. Like it happens more than you think. So this is an official challenge from ARNA to their court. Individuals can do this too, like non-nationals. The problem is they don't have a nationality. Being a subject citizen, you're a bit limited in your defenses you can raise because you're literally just subject by contract to whatever they're doing to you. But if you have your nationality and a jurisdiction that can step in on your behalf, it adds like more weight to trying to use these type of documents to get remedy. So then we have the same case law on corporator doctrine here that we can use. So between like all three of these, this action in quo warranto, the notice of suspension, letters rogatory, we can pretty much kill any case against you, like anything. You know what I'm saying? Even like in certain traffic ticket situations, we have another affidavit for tickets, but in certain times, I think we can use the notice of suspension to get rid of those claims as well, for example. So we have basically inexhaustible resources and defenses we can use to get you out of a jam. Basically, the point I'm trying to make. So I think that's it that I have for today.